Hello, my name is Austin Gilly, and my fatherhood is on trial with AI. By this point, I was hopeful because the expert my parents helped pay for is highly qualified. His name is Dr. Alan Blotcky. He is a clinical and forensic psychologist out of Birmingham, Alabama, and he was retained in 2023 and provided advice to my legal counsel. He reviewed the case record I provided, visit notes, the court therapist's letter, and my running account of where the case stood. His report in preparation for the trial came on July 30th, 2024. Claude observes that Blotcky's qualifications cover the exact case domains: childhood development, family dynamics, child custody, parental alienation, and false allegations of abuse. He applied the five-factor model, a diagnostic standard for parental alienation, in his field. The child resists or refuses contact with the parent. The child and parent had a good prior relationship. There is no abuse or neglect by the rejected parent. The favored parent engages in some or many alienating behaviors, and the child is showing some or many characteristics of an alienated child. All five were present in our case. He wrote that my children are severely alienated. His conclusion was direct, and he indicated it amounted to child psychological abuse and a psychiatric emergency. He wrote that the reunification therapy the court had ordered was, and I want to use his word here because it is one he chose, doomed. Doomed because it was not going to be carried out with the dynamics of parental alienation in mind. No therapy can work when one parent is undermining the therapeutic process. He recommended the treatment protocol for severe alienation. All four children should be removed from their mother's care and placed with their father. The children must have no contact with the offending parent for at least 90 days. Mom must have individual therapy with a clinician skilled in parental alienation. I and my children must have reunification therapy with a clinician steeped in the field. Both components have to happen simultaneously or it does not work. Blotcky closed by saying, quote, decisive and compelling court intervention is required. The trial was set for August 21 and 23. Blotcky was my expert, and the plan was that he would testify. On August 13th, Mom's attorney asked for more time to depose the expert and possibly find his own expert. The trial was delayed to accommodate, but neither of those things happened. Instead, on September 13th, Mom's attorney filed a motion to ask the judge to exclude Blotcky's testimony from trial. My attorney filed a response, and the legal fighting just continued. On October 3, 2024, the court denied the motion to prevent the psychologist from testifying. The judge also found that reunification therapy was not complete. On December 4, 2024, Mom's attorney filed another motion, and it contained, among other items, Item 7, a request to bifurcate the trial, to split the property issues away from the custody issues and try them separately. The judge ruled the next day that the property trial would go forward in January 2025. The custody trial, the one in which the psychologist's testimony about the framework, the diagnosis, and the children's situation would have been adjudicated, would not be included. Meanwhile, the reunification therapy was continuing and was failing. Instead of moving toward reunifying, on October 16, 2024, my oldest daughter filed a petition asking the court to change her surname legally to her maternal grandparents' name. That same day, the court-appointed reunification therapist billed for a 1-hour appointment with her. She also billed for a 1-hour appointment with my son and a 1-hour appointment with my middle daughter. The next day, she billed for a 1-hour appointment with youngest daughter. 4 reunification appointments, 24 hours. I paid for all of them. Claude observes, quote, by the operational framework Trotter's office was billing under, this is the opposite of what the treatment is supposed to produce. The patients were not reuniting. They were separating further. And the court forced me to pay for it. I was still looking for a way to continue paying for the therapy for the kids while also still being required to pay all marital debts. On November 14th, 2024, my attorney filed a motion to force the proposal that had been offered for several years to cash out a pension to pay off marital debts to free up cash flow to pay for the therapist. The judge denied the request but did split the property and custody issues, and the property trial happened on January 23rd and January 30th, 2025, over 2 days. The transcripts run several hundred pages, and Claude analyzed them all. During the trial, Mom testified that she had arranged for alternative phones and phone numbers for all the kids over a year prior, and has never to this day informed me or shared the numbers with me. She just let me keep paying the bill. But that wasn't the most shocking revelation of that trial. The most shocking was that Mom's attorney, after years of objection and 2 days of trial, changed his position at the last minute. He agreed with me and called me noble for the proposal that left his client completely debt-free. Despite the change in tune, the uncooperative behaviors did not change, and nothing would get executed for another full year. Instead, Mom's attorney garnished my wages, filed more contempt charges, and the therapist billed me another $8,000 for largely administrative, non-clinical work. The therapy for the kids was again at a standstill because I could not pay the bill. Mom was ordered in 2022 to pay for her desired wellness membership for her and the kids. Through 2025, she continued to submit expense reimbursements to me, and I finally had to withdraw permission for that naturopath to continue treatment, especially since the naturopath was treating anxiety and not for the child abuse that the clinical psychologist had recommended. I later learned that Mom had not paid the naturopath clinic in years, and she was not paying anything that she was ordered to pay as a result of the property trial, such as her car payment and car insurance. The financial toll of the divorce was in fact hurting everyone. By April 2025, I had been carrying the financial weight of the case for 35 months, and there was no cooperation or relief from the trial order that granted it. There was just more lawyering, and the reunification therapy was not happening, and I was still not seeing my children. In desperation, on April 6, 2025, I posted to GoFundMe. Claude calls it, quote, the densest framework articulation I had produced. And Claude observes, quote, the articulation is happening on the platform because the formal channels had stopped functioning at the substantive register. Instead of cooperating on the property trial order, the lawyers argued about the order. And on May 1st, 2025, the third amended contempt was on the docket, making 6 total contempt citations so far in the case by Mom's attorney. No one seemed to believe that there was no money, and no one had any urgency to solve the issue. During this time, I had to rely on grocery donations to eat. On June 30th, 2025, my counsel filed a motion to force the property trial order, given that the property trial had occurred in January and the issues had already been adjudicated. On July 16th, 2025, Mom's attorney filed an objection. Still no cooperation. And it was the same day my mother was diagnosed with breast cancer. Just like with my dad's stroke the year before, Mom and the kids ignored their once beloved grandparents. And by August, I was out of money and could not afford rent. I made the decision to move out of state until some legal direction was provided. The therapist had written that my kids might be monitoring my GoFundMe site, so I posted a temporary goodbye. On August 7th, 2025, the judge sustained my motion. He approved the decree of dissolution. Unfortunately, no financial relief would come until February of 2026, after Mom finally signed the same paper she could have signed 3 years earlier for everyone's benefit. The judge also set the custody trial for November 5 and November 7, 2025. I arrived 2 days before the trial, only to find out the trial would be delayed because the therapist would not participate or respond to a subpoena. My attorney had to ask the court to require its own appointed therapist to cooperate. What would she and the court do?